Hello, I'm Pam Morales.
I'm Liana McClinton.
I'm Evan Wilker.
I'm Ada Watkins, and we are in group 36.
Okay, I'll begin. The question at hand is whether an employer can impose distinct grooming and dress standards for male and female employees without violating Title VII's prohibition on sex discrimination. In this jurisdiction, I will argue that no, that an employer cannot legally impose different grooming and dress standards based on gender, as it would be a violation of Title VII. This jurisdiction has not addressed this specific issue, providing an opportunity to establish a precedent from Price Waterhouse versus Hopkins 1989 case. Justification is essential through a careful interpretation of Title VII. Title VII of the Civil Rights Act prohibits sex discrimination in employment based on race, color, religion, sex, and national origin. The language of Title VII is broad and prohibits employers from discriminating against employees on the basis of sex in the workplace. Grooming and dress standards that differentiate between male and female employees would inherently treat individuals differently based on their sex, which goes against the principles of Title VII. But Title VII does not explicitly allow for differentiation based on gender in grooming and dress standards. Therefore, a court should interpret it to prohibit such distinctions unless a compelling reason can be demonstrated. When interpreting Title VII, a court should adopt a purposeful approach considering the statute's overarching goal of eliminating gender-based discrimination in the workplace. It should think about the main goal of getting rid of unfair treatment based on gender at work. Title VII does not only talk about hiring and firing, it also hints at treating everyone the same, even when it comes to how people look or dress. Even though Title VII doesn't specifically talk about how people should dress, it does say that treating someone differently because of their gender goes against the idea of fairness in the law. Even if the words in Title VII don't directly talk about how people should dress, the rule against treating someone differently because of their gender can be used to argue against rules and about how men and women should dress differently. The court should recognize that regulations dictating individuals' appearances have the potential to perpetuate stereotypes about men and women, which again goes against Title VII, which is what they're trying to achieve. Instead of just looking at the exact words of Title VII, the court should see it as a law that can change and adapt to new issues, like unfair rules about how people should look. The court should think about Title VII not as just words on paper, but as a tool to fight against things that make the workplace unfair, like rules about how people should dress based on their gender. Further, these rules about how people should look might make the workplace uncomfortable for some people because it is sticking to old-fashioned traditional ideas about how men and women should act. To support the idea of interpreting Title VII more broadly, we can say that the law should keep up of how society is changing, especially in areas where ideas about how men and women should act are always changing. Courts should follow the idea of making sure everyone's treated fairly, not just in words, but in how things work, how things really work to get rid of barriers that make it harder for men and women to be equal at work. In Price Waterhouse versus Hopkins, it is a case dealt with gender stereotyping in the workplace. In Price Waterhouse, the court emphasized the importance of eliminating gender stereotypes in the importance of eliminating gender stereotypes in employment decisions, providing a foundation for a broad interpretation of Title VII in our case. Despite her qualifications and strong performance record, Hopkins was denied partnership because some of the partners at the firm believed she did not conform to their expectations of how a woman should behave and present herself. In this case, the Supreme Court held that sex stereotyping is a form of sex discrimination under Title VII. Applying this precedent, any grooming or dress code that enforces stereotypical norms or expectations based on gender roles would likely be deemed as discriminatory. Hopkins was advised to walk, talk, dress more femininely, wear makeup, have her hair styled, wear jewelry. And one partner described her as macho, and another said she was overcompensated for being a woman. And a third told her to take a course at a charm school. Impermissible sex stereotyping was clear because the traits she was asked to hide were the same traits considered praiseworthy in men. While Price Waterhouse dealt with promotions and not grooming standards, the underlying principle of combating gender-based stereotypes is applicable, making it a valuable reference for the court to consider the broad implications of gender-related workplace regulations. Price Waterhouse can be used as an example of a case where the court did the right thing by focusing on getting rid of unfair ideas about gender. This supports the idea of our case challenging gender-specific grooming rules, which should be treated similarly. Our case should reject any argument that relies on old-fashioned ideas about how women and men should act. As Price Waterhouse already said, these ideas have no place in modern workplace. By comparing the details of Price Waterhouse with our case, where the issue is about grooming rules, it straightens the argument that any rules based on gender, whether hiring or appearance, are not fair and should not be followed. Price Waterhouse serves as an example for the court, emphasizing the rejection of biased gender policies. By removing stereotypes, it supports our case not just legally, but as a good policy for workplace fairness. By removing stereotypes, it supports our case not just legally, but for fairness. Any attempt to justify gender-specific dress rules using old-fashioned ideas should be dismissed, which aligns with Price Waterhouse's call to move beyond such notions in the workplace. Building on Price Waterhouse, a court is likely to scrutinize grooming rules to prevent reinforcing harmful stereotypes, which is in line with Title VII's goal of workplace equality. In our case, the court should follow Price Waterhouse guidance, ensuring appearance policies don't perpetuate gender-based discrimination. Rejecting gender-specific dress rules is crucial to avoid sustaining damaging stereotypes and undermining equality goals, which aligns with Price Waterhouse's central themes. By applying Price Waterhouse's ideas to our case, it highlights the importance of challenging and rejecting workplace policies that cause discomfort through gender-based rules. Price Waterhouse provides a framework for the court, emphasizing the need to interpret the law to curb harmful gender stereotypes and promote equality. Price Waterhouse's impact in challenging outdated gender norms supports the idea that rejecting rules on how men and women should dress is not only legally justified, but also crucial for creating equitable workplace policies. In conclusion, the interpretation of Title VII, especially in the light of the precedent set by Price Waterhouse versus Hopkins, supports the argument that an employer cannot legally impose different grooming and dress standards on male and female employees without violating the prohibition on sex discrimination. Such differentiation would perpetuate gender stereotypes, which is contrary to the principles of equality and fairness under Title VII.
Again, my name is Leona McClinton, and I'm also going to discuss the issue of whether an employer can legally impose different grooming and dress standards on male and female employees, or whether this violates Title VII's prohibition on sex discrimination. My answer, no. An employer cannot legally impose different grooming and dress standards on male and female employees because it does violate Title VII's prohibition on sex discrimination. I will start with the evidence found in Title VII. In Part A of Title VII, it discusses employer practices and says, it shall be unlawful employment practice for an employer to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. I'm going to be focusing on the sex part of this part of Title VII. Imposing different grooming and dress standards for men and women classifies employees based on their gender and has a direct adverse effect on their status as an employee. It creates a disparity in the amount of effort put into one's job outside of the workplace. Depending on your sex, you would have to shop for different work clothing, get ready in different ways, and in different amounts of times, among other things. Part B of Title VII says that employment agency practices, it shall be unlawful employment practice for an employment agency to fail or refuse to refer for employment or otherwise to discriminate against any individual because of his race, color, religion, sex, or national origin, or to classify or refer for employment any individual on the basis of his color, race, religion, sex, or national origin. Again, focusing on the sex part of this part of Title VII. Not hiring an individual that does not wish to conform to different grooming standards based on their sex is discriminatory. The right to work, no matter one's sex, is not upheld when you must conform to gender-based rules that you don't agree with. Anyone that wanted to apply for jobs but did not want to follow the sex-based grooming standards would not be able to morally apply for these jobs, and therefore they are at a greater risk of unemployment. In conclusion, firing someone who didn't conform to a sex-based rule of employment is firing someone based on their sex. The only exception, or one of the only exceptions for this rule in Title VII is the bona fide occupational qualification, which says that it is reasonably necessary to the normal operation of that particular business or enterprise for different gender rules to be placed on different genders. Given that gender-based grooming rules are based on subjective stereotypes of how a man or woman should appear, they are not necessary to any work operation. Therefore, the bona fide occupational qualification does not stand as an exception. I will now move to my evidence from two different cases. My first is Price Waterhouse versus Hopkins. This case ruled that an employer did not promote its employee based on sex stereotypes, which goes against the rules of Title VII. The difference between this and the grooming question is that it was based on how an employee already presented themselves. The employee in question was a woman who, as Pam said, dressed macho and therefore was not promoted to a different title because she did not present herself in a way that seemed feminine enough. However, it is similar to the question at hand because it introduced the ideas of sex stereotypes and gave this argument teeth in the law. A quote from this decision says, "We are beyond the day when an employer could evaluate employees by assuming or insisting that they match the stereotype associated with their group." To this I say, gender-based grooming standards are inherently based on sex stereotypes and therefore place unfair expectations on an employee based on their sex. And that is why Price Waterhouse versus Hopkins is relevant. The second case is Jesperson versus Haraz. This ruled that a personal best policy differentiating between the grooming expectation of men and women did not go against Title VII as it placed grooming burdens on both sexes and therefore was not discriminatory. Although the women's personal best policy said that women must wear makeup and the men said that they must not wear makeup, they were considered similar because they were both rules and therefore were not deemed discriminatory. Although it ruled against what I believe in, I believe to be discrimination in grooming practices, I'd like to point to the dissenting opinion to prove my argument. This judge said, the inescapable message of Farrar's grooming policy is that women's undoctored faces compare unfavorably to men's, not because of this physical difference between men and women's faces, but because of a cultural assumption and gender-based stereotype that women's faces are incomplete, unattractive, or unprofessional without makeup. I believe that the dissenting opinion better represents the heart of Title VII than the actual ruling of the Farrar's case, because the majority opinion disregards the fact that although both genders had grooming standards, the females required much more time, effort, and money to uphold, and the males cost nothing. To close out in talking about further policies and sex discrimination laws, I think that to make these laws effective, the issue of personal grooming standards should be prohibited, as it discriminates against the sexes by putting unwarranted and unequal stress on employees.
My name is Evan Wilker, and I will also be discussing that employers cannot require different grooming and dress standards for employees because it violates Title VII's prohibition on sex discrimination. So the text of Title VII claims that employers cannot, quote, limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or other adversely affect his status as an employee, and because of race, color, religion, sex, or national origin. Title VII also says that employers cannot discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment. The only exception for these qualifications is the bona fide occupational qualification that says that the only exception can come in instances where sex is reasonably necessary to the normal operation of the business. So therefore, only in cases where sex is extremely necessary should differences in grooming standards be required. But really, there is no instance in which grooming standards would warrant an exception by the bona fide occupational qualification, because grooming and dress standards do not help people do the requirements within their jobs. The only reason that employers would desire to impose grooming and dress standards is to produce a sense of safety or professionalism in the false normality provided by gender standards. This is not a factor that is necessary for the completion of the job. It is only necessary for the fulfillment of gender stereotypes, which means that Title VII does not support grooming standards. In addition, the Diaz versus Pan Am Airlines case decided in 1971 is further support for this point. In this case, the court ruled that the airline could not refuse to hire men as flight cabin attendants, even though women have historically been the ones to take this job on. The reason I bring this up is because the reasoning behind the case found evidence, even though the reasoning behind the case found evidence that passengers felt more comfortable with female flight attendants, and that females in general are more fit to take into account the psychological needs of their passengers, the court still ruled it was not fair to exclude men from being hired. The court said that the creation of a pleasant atmosphere for customers had no relevance for the reasonable operation of the tasks of flight attendant duties. This shows that the courts have set a precedent that the atmosphere and overall preferences of customers are not enough to require a differentiation between sexes in the workplace. And because the only false benefit that grooming standards would have would be to create an overall preference for customers or an overall theoretically better atmosphere, then this case shows that the courts do not think this is enough of a reason to create differentiation between sexes. The Jesperson versus Haraz case, decided in 2005, also supports that grooming standards should not be allowed that differentiate between sexes. In this case, the court actually did rule against Jesperson, whose claim was that the grooming standards imposed upon her and her operating company were an example of unfair sex stereotyping. But I believe that the court in this case did not take proper regard for the facts of the case. In this case, the court's language says, quote, appearance standards, including makeup requirements, may well be the subject of a Title VII claim for sexual stereotyping, but that on this record, Jesperson has failed to provide sufficient evidence that the challenge policy was part of a policy motivated by sex stereotyping. So basically, the court is saying that it was only the facts of this specific case that caused the court to side this way and not the idea of sex differentiated grooming requirements in general. But the court also did not take account of the facts of this case. In this case, Jesperson had a personal reaction against the requirement that women wear makeup because she highly disliked it and it made her very uncomfortable to wear it. The court claimed that this was simply a personal vendetta against makeup instead of an actual example of sex stereotyping. But in this case, Jesperson claimed that she was adversely impacted in the workplace by the application of makeup to the point where it made her unable to do her job because she was so uncomfortable. And the language of Title VII says that that there cannot be requirements that deprive the employees of employment opportunities and equality. In this case, Jesperson was definitely the employment opportunities were definitely taken away from her because she felt too uncomfortable to do her job. In addition, the dissent within this case properly recognizes the undue burden that these requirements place on women. Because of the time, effort, and money that the daily application of makeup requires, and because there's no such similar requirement for men, it is requiring women to take more time out of their days, and this is an example of sex stereotyping. Dissent also makes the point that requiring the application of makeup is demeaning because it alleges that women's faces are not presentable enough without makeup, while men's faces are, which is also a form of sex stereotyping. This case also references a different decision called the EEOC versus Sage Reality Corp, where it says that the female plaintiff who was required to wear a revealing uniform by the hotel she worked at was a victim of sex stereotyping. And this case was decided in favor of the women. And the fact that the Jesperson case references this case but decides differently shows that it was not a correct decision. All in all, due to the language within Title VII of the Civil Rights Act, the precedent set by Diaz versus Pan Am Airlines, and the falsities within the Jesperson case, grooming standards, differences in grooming and dress standards for employees based on sex should not be allowed.
So I'm Ada Watkins, and my opinion is also the same as everyone else's opinion. I believe that an employer cannot legally impose different grooming and dressing standards on male and female employees because it violates Title VII. The courts should interpret Title VII in more of like a strict manner, and it applies to all cases that could potentially involve sex discrimination in employment when it comes to grooming and dressing standards. So the court should consider the employee's race, sex, color, relation, or national origin and take into account any prejudice the employer might have and how the prejudice might affect the implementation of grooming and dressing standards. Additionally, the court needs to analyze patterns in who the employer has hired or promoted to see if prejudice is present which could cause hidden bias behind dressing and grooming standards. My first case that supports my claim is the 2006 court case Jesperson versus Haraz. Darlene Jefferson was terminated from her position as a bartender at a sports bar in Haraz Reno Casino not long after Haraz began to enforce its personal best program, which required women to wear facial makeup. Darlene was a faithful employee for over 20 years and refused to comply to these standards. The appearance standards included the requirement of wearing makeup. Darlene failed to state that her termination was a violation of Title VII of the Civil Rights Act, so the court did rule in Haraz's favor. If Darlene's termination was seen through the eyes of Title VII violation, then she most likely would have won the case, especially because the Price Waterhouse case was before this and also relates to sex discrimination in the workplace. So this is because women being required to wear makeup is a discrimination due to men not having to also be required to wear makeup. So Darlene was terminated solely on the basis of sex because if she was a male, she would have not been terminated for not wearing makeup. The court's rationale for siding with Haraz was both unlogical and a violation of Title VII. The court's reasoning for the citing was that there was a requirement for both men and women implemented at Haraz, but I believe that the requirement for women were more strict. The requirement stated, quote, makeup, parentheses, face powder, blush, mascara must be worn and applied neatly in complementary colors. Lip color must be worn at all times, parentheses, emphasis added, end quote. As you can see, there's lots of things that women have to comply to, and it's very detailed and very strict. The requirement for wearing makeup is not only sexist, but also puts women at a disadvantage. This is because women must spend time picking out makeup, applying it, and spending money buying it. Although these tasks might seem trivial at first, over time it can heavily and negatively affect a woman's life, both mentally and financially, due to having to stress about how she looks and how much money she'll spend on how she looks. The personal best program is also implying that a woman is not her best when she is not wearing makeup and complying to the standards created. In conclusion, the court's decision to rule in Haraz's favor was a violation of Title VII, and they should have ruled in Darlene's favor. In order to avoid this problem in the courts again, I think Title VII should be revised to include any requirements placed on employees due to their race, color, religion, sex, or national origin is a violation of Title VII. Not just how they're doing in the job, like being fired or being promoted or demoted. Making these adjustments would make Title VII more specific and will minimize discrimination in the workplace. My next case I'm going to talk about is Bostock versus Clayton County, Georgia. And in this case, they bring up multiple times when homosexual people were discriminated against at their job. Although these discriminatory events were due to the employee's sexuality, violation of Title VII due to grooming and dressing standards also play a role. Amy Steffens works at a funeral home, and after transitioning to a woman, she was fired. Although the main reason for her being fired was because her workplace was transphobic, they also discriminated against her because she didn't comply to the societal standards of looking and dressing as a man. Amy's gender is woman, but she is still biologically a male and started at the job and was hired as a male. This means that the grooming and dressing standards of being a male will unfortunately still follow her, and especially be prevalent at the workforce. Although this case does not have teeth due to the topic of sexuality never being brought to light in the court system before, the court still did realize that the firing of Amy was a violation of Title VII. So it did support that Title VII enforces the grooming and dressing standards based on the employee's race, sex, color, religion, or national origin is a violation of Title VII, but it should also include sexuality. Although it hasn't been updated, I think that it should. I believe that the sex discrimination laws should enforce Title VII's Okay. Sorry. So I believe that Title VII should be implemented more and seen more. Sorry. Yeah, that's all I have.
That's your try.
Oh, I believe that this that the sex discrimination law should enforce Title VII's employment regulation standards so it can better promote equality in the workforce and prohibit the implementation of grooming and dressing standards based on gender. Sorry, I don't know why that was so hard.
And now we should move on to our 30-minute discussion, which I will start timing.
Okay. Do we?
So, wanna review each other's arguments?
First, I want to say I think everyone did a really good job, especially Pam. Shout out to Pam. I thought you brought a lot to the table and really dove deep into how your court cases reflect your claim. I especially like when you said how Title VII should be seen as not just words on paper. I thought that was a really good quote because I feel like everything that is in the Constitution is like everyone like praises the exact words, even if they were created a really long time ago. So yeah, especially because society is constantly changing and we can't always follow traditional ideas. I think this also relates to the abortion laws that we talked about in class today, especially the Dobbs court case when they were saying abortions have never been talked about in common law or the Constitution, so we shouldn't have them. Obviously, I don't think that is right because obviously, like times are changing. We can't always stick with things we decided or didn't talk about in the past, especially hundreds of years ago. So, yeah, I just think we should keep in mind that times are changing, and so should the laws.
I agree with that. But going off of the abortion thing, it also reminded me of the hypocrisy of always bringing up the Second Amendment, even though the Second Amendment protects your right to an antique. Like they had muskets that took 7 minutes to load. And so it was
what the Second Amendment is. Sorry, I don't know what the Second
right
Amendment is.
to bear arms.
Oh,
to have
okay.
guns.
I didn't know that. Okay, sorry.
And so I think it's interesting that people are so hell bent on having access to military grade weapons, even though those were not guaranteed in the Constitution, but because we've never talked about women in the Constitution or abortion, that's not our right. It's definitely hypocritical. And I like the use of the term tool. I don't know if you said that, but saying that the Title VII should be used as a tool for things that change and adapt to new issues instead of like a firm hand. I like that idea as well.
I liked what you were talking about when you were saying like that the sex, like the sex stereotyping and like grooming standards in the Jesperson case were basically just saying that women's faces weren't good enough without makeup. And I feel like that's like a big issue. I mean, a lot of people brought that up, but the way that women's faces are like they have to be enhanced in order to be like seen as professional is like such a double standard because like I was reading in the Jesperson case, one of the things that they were talking about is that like men are supposed to shave, so that's like the facial requirement that's equivalent to women wearing makeup, but that is just like a man like revealing his face more and like making it more visible and while women are supposed to like cover up their faces with other products. It's so double standard.
And like, especially with that, like, I feel like, well, I don't know if you guys have like worked in a restaurant, but like, I worked in a restaurant and like, you can't have a beard or like make have beards because like it'll get into the food. So it was more of like that was actually like keeping the workplace sanitary while makeup wasn't actually doing anything. It's not like it's increasing her like productivity at work or making the customers buy more. It's not like it's actually increasing like the profit of the company. So I just think that was just really unlogical of like
Yeah.
a standard.
Like she was still good at her job.
Yeah,
Yeah.
especially being having worked there like 20 years.
Yeah.
Mhm.
Yeah.
And also with the beard thing, I mean, requiring men to shave their beards has a purpose, but also I feel like a lot of places require women to have makeup on, but also shave their armpits. A lot of restaurants don't let women have armpit hair,
Mhm.
and a lot of private schools don't let girls have hairy legs. Like they have to shave their legs. Same with like Hooters and stuff. So like, yeah, men have to shave their faces, but women have to shave their entire bodies
Yeah.
and put on makeup because you have to shave your face to put on makeup well in some people's opinion. So yeah, that doesn't hold up.
Yeah. Any form of like body hair is seen as like disgusted by the public, but if it was on like a man, then it's
Yeah.
not as much.
It would just like make him more manly. And,
Yeah.
like and Evan, I really liked how you said, like, also keeping with the Jefferson case, how it made her uncomfortable to wear makeup, and then she wasn't able to do her job as well. I feel like even though that's like just how she feels, I feel like it's a really big part of it. If you like can't mentally be able to do your job, like obviously it's gonna take a toll on her, and it's gonna be worse for the company. So she's like the restaurant's gonna make less of a profit, and yeah, I feel like it's like the court's not taking into account how women emotionally feel when these regulations are put on them.
Definitely not. Like if it's to the point where you are so like you feel so out of place and not yourself that you like can't properly work, then like that is obviously sex discrimination, I feel like, because if she was a man, she wouldn't have to wear makeup, and she's a woman, she has to wear makeup, and therefore she feels so like awkward and out of place that she literally quit her, like she would rather quit her job that she'd been working at for 20 years than like wear the makeup, which is just like a testimony to what you were saying, like how the courts just don't take into account the emotional impact.
Yeah. Like you were saying, her employment opportunities were taken.
Yeah.
And that kind of reminds me of what we were talking about before we started recording with the case about bakers not making cakes for gay couples
Yeah.
because their emotions were taken into account when they ruled that they didn't have to make cakes for gay couples, but her emotions aren't taken into account so an employer has more emotional rights than the employee, which is hypocritical and goes against the Constitution, in my opinion.
So I know we all agreed, we were all very unanimous with how um, dress and grooming standards should not be implemented. But if there were to be a countering opinion, what do you think that could be?
I mean, I feel like Jesperson is a good example of the counter opinion, like with saying, like, because like a lot of the grooming standards on there were just like cleanliness stuff, I guess, or just like presentability stuff. But then, like the places where it started differentiating between men and women, like it, at least in that case, they argued that it was just like the same burden on both genders. Because like one requirement was that men couldn't have long hair, and it was like since men can't have long hair and women have to do this, it's like the same burden on both of them. So therefore, it's not creating any employment differences. But that just seems like why would you create a burden on both genders when you could just create a burden on no genders? That doesn't really make sense.
That's the way.
Or just make like a universal, like all employees have to be
Yeah,
clean,
yeah.
like I see where they're coming from, but they just did not do it correctly.
Right.
I know you were talking about the Pam Ann case, and I think that went really well with this, and I hadn't thought about it in comparison. And he said that precedents. What did you say? The precedents that atmosphere and customer preferences are like important does not justify different standards for men. I think that makes a lot of sense, but I also think um, more conservative people might argue that like to some businesses, atmosphere and customer preferences is like the root of it, especially if they're like a like if they're in customer relations or something, like their customer preferences do matter, and therefore like what is the norm should be taken into consideration to run a successful business. And so it's that bona fide occupational thing that people want to see pretty women, and if business deems that right, they should have the right to do that. Trump 2024.
Um, yeah, I think like people like, I don't know, they see like females in general like as like nurturing and like someone who takes care of you. So that's why I guess like they want like female flight attendants. They feel more comfortable. So I guess maybe that's why they wouldn't like hire males. And like, you know, just like the pretty picture. Yeah.
Yeah. I just thought it was it was interesting in that case because like the like flight attendant industry is a lot about like customer pleasure, and like the whole point of a flight attendant is to like make everybody feel good about their flight and to like get the plane company good reviews. But it was interesting in that case how they said they like explicitly wrote out how customer preference shouldn't be taken into account like during the hiring process. And so I feel like, or not taken into account, but they were like, the fact that customers might feel a little bit more comfortable with women shouldn't be like a cause to not hire any men. And so I feel like it's interesting. I mean, that could be like,
Okay, I get it.
um,
Yeah. I also feel like this could also relate to like the Price Waterhouse case, like seeing like the 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 opposite like just seeing the other side of it, I guess. Wait, where did she work? I feel like it was like a more like masculine dominated
It was,
Yeah,
field, right?
it was in the
Um,
office, I know.
Yeah. So,
Finance.
mhm. So like she was like like hated on because she didn't act like feminine, and I also don't know where I was going with that.
well, I think
Like it could have made everything a little bit more amiable.
Yeah.
There could have been more peace, but I feel like it would have just been easier for like the men to change their opinion about her than for her to change for them.
Yeah.
But yeah.
And I think when discussing the counter argument, it cracks us up so much, is because it's so ridiculous. Because the counter argument is almost entirely based in feelings, and it just kind of feels like crybabies. Like that your feelings should not go into the law. That's why the law was made, so that we can make objective opinions about things. And so, although it's unprofessional of us to laugh, especially me, I'm sorry. It's just hard to take something seriously that is completely against what it's arguing for. Yeah.
Um, I thought it was interesting how you brought up the Bostock versus Clayton County case because I didn't really think about that one as much in terms of this assignment, but I think that like it's definitely a really good example of how like I liked what you said about how she was like followed and like haunted by the grooming standards of being a male, even though she wasn't presenting as a man. And like I thought it was a good argument for like how sex, like, I guess it's not like a concrete example of like, it's not like they were imposing grooming. Wait, it's like the societal grooming standards, like the that society just like puts out to people, even if they're not like explicitly stated. I thought that was interesting.
I agree. This makes no sense. I wrote down for the Bostock case, crossbred teeth are stronger. And what I meant is like we were talking about how like a case is stronger if it has teeth, if it has like foundations in the law. And I was just thinking like when you can compare it to sexuality discrimination and race discrimination and what are the other things we've talked about? All of those things, it makes your case stronger because they're all like interconnected. So the Bostock case was important because it showed another type of discrimination that was very similar. But,
So just to tie this into psychology, I feel like especially with like people part of like the LGBTQ plus community, there are more like there's like standards coming from both sides. It's, like especially with like trans people, like it's like oh like they're still being like haunted by the grooming standards of like their biological gender, but also we were talking about in psychology how like trans men like develop like eating disorders because they're like really trying to look feminine because society is like, oh, like yeah, okay, if you're trans, we have to look more feminine. I don't know. I just thought that was really interesting. I never had heard like that side before, but yeah, there. I just think it's like sad that it's like coming from both sides almost. It's actually so random.
no, it
That
makes
was
sense.
good.
I liked it.
Should we move to this?
Okay. We're halfway
Oh,
through, so
Sure. Okay. So now we're gonna seek to agree on the strongest possible arguments either in favor or against legalizing sex differentiation.
we've kind of dipped our toe in this pool. Let's
Mm-hmm.
expand.
I agree. That's an excellent idea, man.
Well, I feel like the Jesperson case is definitely one of the strongest arguments because we basically all
We all
talked about that. And it is like, I mean, even though it's again like the court's final decision was not in favor of our opinion, like breaking it down, we can really like get some information for that.
Yes.
The language of Title VII is also
Important. Where should we start? Where should we dig in? Let's start with Title VII because then we can compare the use of Title VII in Jesperson versus Ross.
Yes.
Would you guys like me to read the quote again?
Yeah.
Can you
Absolutely love
elaborate? So let's talk about Part A of Title VII. It says employer practices.
pause it for a second.
All right, so Part A of Title VII refers to employer practices and says it shall be an unlawful employment practice for an employer to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. So how do we interpret this in common terms?
Well, I mean, I definitely interpret this as grooming standards because they're segregating or classifying the employees in a way that would tend, and some of these grooming standards could deprive any individual of employment or could affect their status as an employee because they would negatively affect the employee's mental well-being and comfortability. Um,
Yeah, I think it's a little bit weak because it just is talking about like being employed or being fired or being promoted or demoted, and it doesn't take it into account like people can still be like mistreated without like their job being like on the line. So I feel like it should
Yeah.
also like have a like, wider scope and talk more about treatment in the workplace, and also like touch on sexuality and stuff.
Mhm.
yeah.
Yeah.
Yeah,
And-
the part where it says that like the employers can't discriminate with respect to compensation terms, conditions, or privileges of employment, like that's what you're saying, like only like the benefits or like promotions or stuff like that that come with the job and not like the actual, it doesn't talk so much about the actual treatment by like other people within the workplace.
Mhm. I think also, even though it should be implicit, it needs to specify that like um, cultural norms don't matter, especially in these cases, so that employees can't just say, "Oh well, it is important. It is a bona fide occupational thing because this is just the way things are." Because it doesn't really say anything about that, and so people have used that argument time and time again. I also think now that we've made the argument that sex is biological, gender should be added in there because people can just say there's inherent biological differences, whether or not that's true, and so gender needs to be taken into consideration as well.
I think what would also like I kind of think about like how like if like things were different, like how these court cases would be interpreted. I think if like the Equal Rights Amendment had been passed, which um, invalidate many states and federal laws that discriminate against women. Like I think if that was passed, I think like and the Haraz case was like now, then I think it would have favored in like Jefferson's favor. And I think a lot of other court cases like that would um, favor in the like opinion of person who's being discriminated against that would be like a woman. So I just think like the ERA would definitely help with like shutting down these like discriminations and just create more equality in the workforce. So I think it should be passed.
Um, yeah, I agree. I think it should have been passed because, like you said, it's just an opportunity for everyone to just like be treated equally. And it would definitely change societal norms, and expectations regarding like gender roles and equality, which aligns with the Constitution with contemporary views. Yeah, I don't know. I just think like, and like what you said earlier, it's not as strong because it didn't like really go into the sexuality, which I think it should have, because it's like not clear. So then people like I guess can misinterpret the the law, if that makes sense.
And what go
Yeah.
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 Um, I think one thing that we can talk about with the Title VII is the bona fide occupational qualification because the language is so vague. Because the only, like, the whole exception is that it's in cases where the factors are reasonably necessary to the normal operation of the business, but reasonably necessary is such a, like you could interpret that in so many ways. Because it's not just saying that it has to be necessary, it has to be, like, reasonably necessary, which means that like the courts could probably stretch that so much and like like maybe that's part of the reason that like the Jesperson case didn't go in her favor, and so I think that needs to be like qualified.
I agree. Um, I think it being specified is important also because although judges' whole job is to be objective and not let their opinions come into it, especially in recent years with the abortion laws, we see that their personal opinions are going to come into it. So if you say that they're reasonably necessary to the normal operation of the business to somebody who's conservative and thinks women should be put in their place, whether you like it or not, and whether they're not doing their job correctly, they are going to rule in favor of the business. So, really, just all of Title VII needs to be like have more of a firm hand on these policies.
And going back to what you said, Evan, about like how the bona fide occupation. Wait, if you say it was like, it wasn't like,
I said it was made.
yeah, yeah. I think this also, sorry, sorry. I feel like this is also shown in the like the VMI case. Like it showed that like when men and women can both like attend the school and like they're at the same level, and it's not like, oh, like men are the only ones capable of going to the school. And from from our psych lecture, like not our psych lecture, our law lecture, like it showed like how like there's overlap, like a ton of overlap between men and women's like skills and abilities, and it's not like one significant. So,
No, I like it. And I think visuals are very helpful for people. Um, we kind of already talked about that. 4 minutes. I think.
We haven't talked that much about the Price Waterhouse case, I feel like. And I think that is definitely a very good, like, could be one of the strongest arguments in our favor because I feel like we've already covered like all the reasons why that is, but I just feel like it's a good example of how sex stereotyping and differentiating by people's appearances is, or like grooming standards do lead to stereotyping and the lack of job opportunities and deniement of partnership.
Especially because in our situation, we're in a circuit that has never ever voted on sex discrimination laws, and therefore we don't have any teeth. I think this one is especially potent because it makes very, very like concise arguments for why sex stereotyping is present in this case. Like when they said, we are beyond the day when an employer could evaluate employees by assuming or insisting that they match the stereotype associated with their group. They just really hashed out the idea that stereotypes are bad.
Yeah, I mean, I guess going back to the Price Waterhouse case that I talked about. Like it was just talking about like it was just about just how it just like really shut her down. I feel like even though she's like in an environment like a workplace, like you should be like you should feel like comfortable and like look forwarding to go to work. But for her, like I feel like she was just being like attacked or not attacked, but like always like being come at like by these men because she was, I guess, not the stereotypical how a female should be. So yeah, I don't know where I was going with that, but like, I don't know. I guess just like in like all these cases, I feel like there has been like restrictions and rules for both men and women, but I feel like it was stricter for women or females more.
Did you guys say that your opinions have changed at all over the course of this discussion?
I feel like my opinion has been affirmed by hearing the same perspective, but like interpreted in different ways. Because even though we all use some of the same stuff, like we all obviously use Title VII, there was like multiple different cases that were brought up in support of the same point. So I guess this kind of shows how like how the our perspective is like the most correct perspective, because there are so many cases that can be interpreted in our favor.
I agree.
Yeah.
Yeah.
They should put us in the courts. So as this question, we're supposed to talk about what we agree are the strongest possible arguments, like out of all of them. I feel like, in my opinion, Price or the Jesperson case and the Bostock versus Clayton County case are some of the strongest.
Yeah.
And specifically talking about grooming service.
I agree. I think
I think we're all in agreement, to be honest. And it looks like that might be our time, guys.
Yeah. Thank you so much.
Thank
for-
you.
for
Thank
listening
you
to-
so much.